Hello, my wonderful people. I trust you are doing very well. You are welcome to another tutorial with us. Today, we are talking about something very well interesting for me and also pretty straightforward. We are talking about constitutional amendments. Now, for those that are new to this channel, we would encourage you all to subscribe to the channel, just share it, like it, comment if you have a question. We'll do our very best to answer. You can also search for us on our socials, LinkedIn, Instagram, Twitter, and let's get interactive. So, yes, so constitutional amendments. So, where do I start from? Yes. So, what is a constitution? So, a constitution in Ghana is it's basically, or someone will say, the 1992 Constitution. Well, that may be true, but not entirely true, because when we are talking about a constitution, there's actually two ways that you can look at it: the narrow definition and the broader definition. The narrow definition will tell you that the constitution is a document. However, the broad definition tells you that a constitution goes beyond just a document to include the customs, the usages, the traditions, all that make up a society. They all form part of the constitution. But for the purposes of this class, we are looking at the narrow definition of a constitution, which is that the constitution is a document that contains all the rules and principles that are applicable for the management of a country. Good. So essentially, we want to understand how a constitution can be changed, because as you will understand, and even for Ghana, our constitution was promulgated in 1992. So it is 92 to 2023. It's about 31 years now. So definitely times may have changed. So it's possible for a few portions of it, to be a bit outdated and not meet the current trends. So in such a situation, how do we amend such provisions of the Constitution? Let me say from the onset that not every provision of the Constitution is open for um, amendment easily. So maybe that's how best I can put it. But as we go into the meat of it, you would understand what I'm saying, which is that there are certain portions of the Constitution that can be amended fairly easily, and then there are other portions of the Constitution that would require a lot of work for it to be amended. The whole idea is that such constitutional, or let me say, such articles of the Constitution are very important for the sustenance of the country, that our the framers of the Constitution thought that it was necessary for such clauses or such articles to be preserved. So before such articles can be amended, then it means that we really need an amendment on those provisions. But as we delve much deeper into it, you would get to understand all that we are talking about. So let's start. Let me get my pointer here. Excellent. So yes, so like all laws, constitutions may be subject to an amendment, but I mean, as I said, they are depending on the nature or the substance of that particular article, it may be fairly easy or fairly difficult to amend it. And the mode of amendment, for every country differs. So every country, and then how they may choose to amend their constitution. And the whole essence of amending the constitution is to ensure that the provisions of the constitution reflect the needs and aspirations of the people. So we cannot be in 2023 and we have 1970 or 1901 constitution still guiding us. That cannot work. Even with our 1992 constitution, there has been a call, for a further amendment of certain provisions, and this is based on the backdrop that we are in changing times, and some of the provisions does not support the current trends that we have. So under our constitution, chapter 25, is set out in providing the guidelines for amending the constitution. Then again, let me repeat that this amendment is on the narrow definition of the constitution. So we are not talking about the broad idea of the constitution, where we are looking at, the customs, the practices, the usages, existing laws, and all the other. We are just looking at the one single book called the constitution. So in this case, how do we amend the 1992 Constitution of Ghana? That is what we want to learn this evening. So under Article 289, the Constitution may be amended by an act of Parliament. So meaning that the President cannot amend the Constitution, neither can the judges of the Supreme Court amend the Constitution. It can be amended by an act, meaning that if we want to change an article of the Constitution, Parliament must pass an act amending that particular provision. So if you don't know what an act of Parliament is, you can listen to our other discussions on the sources of law. It's a video on our channel. You can check it out, where we discuss the various sources of law. So the Constitution can only be amended by an act of Parliament. So Parliament would have to pass a law, and then the law stating that it is amending this portion of the Constitution. But the position that this is not just an ordinary, act of Parliament. It's a very special act of Parliament, and the purpose of this act is to amend the Constitution and nothing more. So meaning that you cannot pass such an act where it's amending the Constitution and it is also talking about revenue, or it's also talking about oil. No, that particular act must only be passed for the sole purpose of amending the Constitution. So if the particular act or law is passed, which includes other provisions that deals with maybe human rights and whatnot, it's a problematic. That's not what the Constitution allows for amending it. So it's a special, type of act, and it must be passed solely for the purpose of amending that particular provision that we, the people of Ghana, believe ought to be amended, and we, the people of Ghana, are being represented by the members of Parliament. So when you look at Article 106, it seems to provide a general idea on how laws are made by Parliament. So it is a bill, followed by a memorandum, with all the proceedings in Parliament, the debates and all that, be published in the Gazette and all that. I mean, that is a general provision dealing with how laws are passed. When it comes to laws being passed for amending the Constitution, it's a separate provision that deals with that. So let's kindly know that I've already mentioned that it is Article 289 under Chapter 25 of the 1992 Constitution. So any student that intends answering any question on this should kindly know this, and it would also be helpful for you to also note Article 106 and try to distinguish it from Article 289 by saying that under Article 106, it provides a general overview of how laws are passed, how they move from it being a bill until it receiving the assent of the president for it to become a law. You can see that under Article 106, but under Article 289, it provides special provisions on amending the Constitution. And we have already mentioned that such an act of Parliament is passed solely for amending it and would not include any other provisions. I hope that that point is made abundantly clear. Let's move on. Good. So I think around 201, if I'm not wrong, there was a Constitutional Review Commission, to look at some of the challenges of the Constitution. And then I think in that process, our very own Professor Kweku Asare, challenged the power of the president to use a commission of inquiry to set in motion a constitutional amendment. So what really happened was that, the president at the time was of the view that um, upon soliciting ideas from the people of Ghana, there was the need for us to amend the constitution. So he did set up a commission of inquiry to look into, proposals in amending the constitution. And Professor Stephen Kweku Asare, was of the view that by the provisions of Article 289 and Chapter 25, the president could not have, set up a commission of inquiry to look into it. So our very own Georgina Wood, CJ, as she then was, stated that amending a constitution is not one event, but the whole process, which may include gathering of information. So let me just summarize, you can always look at this later. But essentially what Georgina Wood, CJ, was saying was that the president was not entirely wrong to set up a committee, to look at the various proposals on certain portions of the constitution, and then that would then inform Parliament to set in motion the actual process of amending the Constitution. So it was not wrong for certain persons to, look, or a commission of inquiry to be set to look into possible, amendments into the Constitution. So essentially, that was what was held in that case. And I agree with that idea, because amending the constitution is not a one-day event. In fact, I think we've had situations where certain persons under a commission of inquiry, moved from a committee, moved from one area or one region to another, soliciting for ideas on how the constitutional amendment process can be done, and for the benefit of the citizen. So definitely it is not a one-day affair, and we'll definitely need time for it to be done properly. Good. So definitely there would be the pre-amendment, stage, as I have said, where a commission of inquiry could come in, sit down, gather proposals on, the various portions of the constitution that may need an amendment. Then afterwards, then an organ of government may also take it up. So the president, may also, say something about it, and then a paper could be a bill, which I should say could be put before Parliament, amending a particular provision. Now, quickly, there are two ways of amending the provisions of the Constitution. Then again, it would depend on whether that particular provision is entrenched or non-entrenched. And this is very, very, very important. I think I earlier made mention of that point. So in amending the constitution, would have to understand entrenched and non-entrenched provisions of the constitution. So the non-entrenched provisions of the constitution are the provisions of the constitution that can easily be amended. They can easily be amended, and obviously the entrenched provisions will be those provisions that cannot be amended easily, if I should put it literally. So that would take more effort in amending such provisions, and you see some of such provision, and I'm sure you understand why they would require more effort for them to be amended compared to the others. So please keep it in mind. We have the non-entrenched provisions and the entrenched provisions in amending the constitution. So you can amend non-entrenched provisions and you can amend entrenched provisions. Amending entrenched provisions are more difficult than amending non-entrenched provisions. Good. So some of the entrenched provisions are Article 1, which is important. Article 2, talks about going before the Supreme Court if you believe that a matter or something is being done. And I mentioned Article 2 because it is very, very popular in constitutional law, which is that if a person alleges that something is being done or an act of parliament contravenes or contradicts the constitution, you can go to the Supreme Court. Also the territories of Ghana, Article 4.5, clearly we cannot allow the territories of Ghana to be amended easily. Also, the laws of Ghana, Article 11, very, 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 very important. Article 11 provides us with the sources of law in Ghana. So it's an entrenched provision. It cannot be amended easily. Same fundamental human rights, very, very important, very, very, very important. Seeing the executive, the legislature, the judicial, all these articles are very important to the soul of the country, meaning that they just cannot be amended easily. So they are all entrenched provisions. So you see, they are so fundamental that any change goes to the heart of the constitutional rule. They form part of the fabric of ensuring constitutional rule in any state. So imagine if it's very easy to change the legislature or the executive. Anybody can just come, change the whole, and then bring in a system, either autocratic or dictatorship or whatever. But these provisions are such fundamental that you just cannot change them easily. That is why they are entrenched provision. So I'm sure you also agree. If you don't agree, you can let us know. So then again, issues of finance, issues of police, the armed forces, they are very, very important to us. So they are classified as entrenched provisions. Good. So the amendment of this provision follows a very special process, and we have outlined it here. So first, there must be a bill. There must be a bill. So a document for the amendment is prepared and must be laid before Parliament. So the Speaker of Parliament would refer the bill to the Council of State for its advice if they have any, and the Council of State have 30 days to respond. Then the bill would be published in the Gazette. So the Gazette, I'm sure for most constitutional laws today, they've been hearing of the word Gazette. So the Gazette is really more like a process where documents from Parliament are more like published. So it's not, it's just a fancy word, but it's just really about just how documents from Parliament are published. So then 6 months after the publication in the Gazette, then the bill will be introduced into Parliament. So first of all, the bill is prepared, it will be laid before Parliament, then the Speaker would refer to the Council of State. Now they have 30 days to look into, then it will be published in the Gazette. Then 6 months after that, it will be introduced into Parliament. Then it will be read for the first time and then referred to a referendum. The referendum is really referred to a vote where we all have a say whether we want a change or not. So that is very, very, very important in the procedure, because as I've already mentioned, these provisions are very core to the constitutional rule of the state. So every citizen needs to have a say in that. So at the referendum, we are saying that at least 40 of the registered voters must vote, and at least 75 must vote in favor of the referendum. So meaning that 40% of we all Ghanaians must vote in that referendum. It's understandable that the number is 40, because of course not many people may show interest, even though such an amendment may have an effect on the life of every Ghanaian. But it has been pegged at 40, just so that we are not overly ambitious. So we have 40 of the registered voters, and at least 75 of the persons voting must say yeah, which is that they want it. Good. So if the amendment is approved at the referendum, then Parliament shall proceed to pass the act amending the constitution. So once Parliament passes it, then the Speaker sends the bill to the President, accompanied by a certificate of the Electoral Commission stating that the bill was approved at a referendum, then the president would assent, then it becomes the law changing the constitution. So it's a very interesting process. We usually don't have this. We usually don't have it because looking at the nature of it, having to set up a whole electoral process for every registered voter to go and vote. Now that definitely costs money, even though not many Ghanaians will turn up for it. So it must be a very, very, very important, article of the constitution that needs amendment for us to go through this process. Good. So I hope it's clear. Good. Now, amending non-entrenched provisions. I've already mentioned that non-entrenched provisions are those provisions that you don't have to hassle, or Parliament need not hassle too much in amending them. And those provisions, they do not affect the very structure and legal order created by the constitution. So they don't affect the judiciary, they don't affect the legislature, they don't affect the executive, they don't affect the police, our finance, our territories, the supremacy of the constitution. They don't affect these very important bits. So, the procedure in amending them is a bit flexible than when these provisions affect the very fabric of Ghanaians. So let's look at the process in amending non-entrenched provisions. So then again, it will also be by a bill. So understand, when it comes to Parliament, it must always be by a bill. Must always be. So it will be a bill to amend the non-entrenched provisions. So in this case, you notice that it will be published in the Gazette. Like entrenched provisions, it is laid before Parliament, and then Parliament would refer it to Council of State for their advice. They have 30 days after it is published. But in this one, it doesn't go through that same route. With this, for non-entrenched provisions, it is published in the Gazette, for it's published in the Gazette for 2 times. So there's a first publication, then after 3 months, there's a second one, then 10 days after it has been published for the second time, it is then introduced to Parliament. So Parliament does its first reading, then the Speaker refers it to the Council of State. So here, you see, the process is a bit different. It's gazetted and published twice before it goes to Parliament, then comes to the Council of State. But for entrenched provisions, it goes to Council of State before it is published, and understand that for that it is published once before it goes to a Parliament for the reading. So same, Council of State, gives the advice in 30 days, then Parliament proceeds to pass the bill. Good. So in this, at least 2/3 of the members of Parliament. So then again, another difference. When you look at entrenched provisions, it's there must be a referendum where at least 40% of the registered voters must vote, and at least we should have 75% of them voting in favor of the referendum. But here it doesn't come for referendum. It is only the members of Parliament that is 2/3, saying 75% of the members of Parliament that must vote in favor of the amendment. And the Speaker sends the bill to President with a certificate that the bill has been passed in accordance with the provision. And I'm sure someone will ask, you did not provide a list of the non-entrenched provision. So it's very simple. All the other provisions that are not part of the list of entrenched provisions are non-entrenched provisions. So you can go and then search for yourself. Good. Thank you. So, a very, very pretty straightforward. So if I would do a very quick recap, all that we are trying to say is that there are times where it becomes necessary for a particular provision of the Constitution to be amended. It may be for various reasons. And looking at, how old our Constitution is going into the future, and maybe, decades to come, there will be a need for us to amend our constitution. Maybe not now, but decades to come, definitely we'll get there. And these provisions, for amending the constitution will come in handy. So I say that there are two ways of amending the constitution. Either you are going through the route in amending non-entrenched provisions or amending entrenched provisions. And I'm saying that non-entrenched provisions are those provisions that do not affect the very fabric of us, or do not affect the constitutional nature of Ghana. But entrenched provisions are the very important provisions that affect our lives, as Ghanaians. And for such reason, amending those provisions must be a bit harder than the other. And we have gone through the procedure for amending a constitution. So I hope the understanding was clear. If you have a question, you can just put it in the comment section or search for us on our socials or get in touch and we'll do very well to answer your question. Thank you very much and have a wonderful day. Once again, if this is your first time, kindly subscribe, just share, like, comment. Yeah. Bye bye.